Loudoun County, Virginia. We know that there was a saga that involved bathrooms, students, transgender issues, and this guy. His name is Scott Ziegler. He was the former superintendent for the entire Loudoun County district. Loudoun County, you can see, is the northern county in Virginia. Seen right here on the map, just so we can get our bearings straight. This individual, Scott Ziegler, the superintendent, was the head of basically the entire county, right? The entire organization. You can see the org chart. He is right there at the top, the superintendent. Everybody reports to this guy. And we on this channel have talked about some of these transgender bathroom issues and some of the parental objections to some of these new policies. We've talked about Merrick Garland, the Biden administration, Department of Homeland Security, FBI, DOJ, everybody calling parents insurrectionists for showing up at schools and protesting some of the decisions that were being made. You may also remember this guy, Scott Smith. He is the father of a victim. Some young woman, some young gal, a child basically, right, in high school, was assaulted by what we're going to hear from the grand jury is a student who was wearing a skirt. So extrapolate from that what you want. But before we get into all of the grand jury reporting, I want you to hear this clip from Scott. Scott is the superintendent, and he is explaining how this stuff works in Loudoun County.
The issue of assaults taking place or transgender students assaulting other students in the restroom, Time magazine in 2016 called that a red herring.
You can see this is the Loudoun County School Board. They're having this, board meeting, and they're talking about these issues. Back at this time, there was a new bathroom policy that they were trying to work through. Parents were objecting. This is Scott Ziegler who is explaining why those concerns are without merit.
The issue of assaults taking place or transgender students assaulting other students in the restroom, Time magazine in 2016 called that a red herring, that the data was simply not playing out, that transgender students were more likely to assault cisgender students in restrooms than were other students.
Time magazine.
In fact, regardless of the gender or gender identity of a student, if a crime or a violation of the rules is committed, that would be investigated and dealt with to the full extent of the rules or the law. So that was Time magazine calling that a red herring.
Time.
That it's not happening.
Not happening.
In fact, in May 2019, the journal Pediatrics did a study in which transgender students concluded that transgender students who are not in an environment that is inclusive and are forced to use the gender ascribed to their birth certificate were more likely to be assaulted than their cisgender peers. So I think it's important to keep.
So the transgender students are actually going to be the ones who are on the receiving end of any abuse. The idea that you have a new transgender policy for bathrooms that suddenly is problematic for cisgender students is now a misnomer, right? That's ridiculous. Time magazine said so, and some other, pediatric study said so. The opposite is true. Transgender students are the ones who are at risk.
Some perspective on this. We've heard it several times tonight from our public speakers, but the predator transgender student or person simply it does not exist, and I think it's part of maybe a misunderstanding of what it means to be transgender, but the data is just simply not playing that out.
Okay, data says it doesn't exist. Okay, this is Scott Ziegler. You can see his name right down here in the bottom right. He is the interim superintendent for the school. This is back at the time when they were having these debates. Says absolutely a myth. There's no data to support whatsoever that there is a transgender predator problem. All right, okay, that's his study. He got it from Time magazine and some pediatric magazine. Got it. All right, so now what happened? Well, there was, unfortunately, several incidents where students were assaulted, right? Several times in two different locations. And so what happened after the community got outraged about it is they demanded that there was an inquiry, that there was some sort of investigation that would take place, and they convened a grand jury. So Virginia wants to figure out what the heck happened in Loudoun County schools. This was the order that was just filed under seal, but now recently unsealed. And this explains exactly what took place. This is coming out of Virginia, the circuit court out of Loudoun County. It is the special grand jury proceedings, and the judge is Honorable James Plowman Jr. He signs off as following. He says, "Order from the court. This matter came before the court on the oral motion of the Commonwealth of Virginia by special counsel to the grand jury," right? So after there was an incident at these schools, which they're going to explain everything that happened here, they convened a grand jury. Special counsel got appointed and said, go investigate this because there is a mess here. And this is the motion to unseal. It appearing that the special grand jury has submitted their final report to the court, and it further appearing that the special grand jury, right, this is a jury of your peers, everybody sits down, they are unanimously wishing for this report to be circulated in the public domain, right? All the people saying, publish this and please read it, America. So the judge said, no problem. Ordered, pursuant to Virginia law, the report of the special grand jury on the investigation of Loudoun County Public Schools is now unsealed. It's going to be unsealed on December 5th. Of course it was. Signed off by the judge. So the people on this, the people who did the investigation, they said everybody has to see this. And here's what the report says. Drafted December 2022, the report of the special grand jury on the Loudoun County Public School investigation. Warning, this report contains sexually explicit material relating to underage people, as well as profane language. So brace yourselves. We, the 9 members of the special grand jury of Loudoun County operating in Loudoun County and paneled at the request of the Office of the Attorney General, now detail our findings. Now, the purpose for convening, they write, was because on October 7, 2021, the Loudoun County Sheriff's Office publicly announced that a teenager had been arrested for battery of a horrific kind and an abduction of a fellow student at Broad Run High School. Okay, so we've got 2 different high schools now. Broad Run. And that all took place on October 7th. Okay, a teenager was arrested October 7th. Wow. Sounds like a terrible ordeal. But just days later, right after that happened, a press report indicated that the assailant, the person who was just arrested, had also committed 2 counts of forcible sodomy on a fellow student at Stonebridge High School, which is different. The new incident was at Broad Run, but back in May, Stonebridge, 2 counts of forcible sodomy. That was on May 28th. Now, that assault occurred in the female restroom while the assailant was wearing a skirt. Okay, so that sounds like the opposite of what Mr. Ziegler communicated to us. And what happened after May 28th? Anybody have any idea what happened after that? 2 counts of forcible sodomy? Like, is that the same student? All right, so it sounds like people were going to be angry about this. Obviously, you're probably sitting in your chair feeling the same. But community outrage ensued. This is from grand jury members. Many questions surrounded how and why Loudoun County Public Schools allowed a student accused of anally raping another student to transfer schools, leading to another assault. Okay? It's the same student. They just moved schools now. National outrage focused on Loudoun County because the student was labeled as gender fluid. Now, LCPS had recently passed, which is Loudoun County, the public school system. They recently passed a transgender policy to conform with the Virginia Department of Education's model policy. And an article linking all of these facts was published just weeks before the highest profile election in the country at the time, the Virginia gubernatorial contest. And so all of this is catching wave, right? Everybody's freaking out. Obviously, students are getting raped in Loudoun County. In an effort to quell public outrage and to deflect blame, the public school system released a statement October 13th. And the superintendent, who we just heard, that is not even close. This is Scott Ziegler. Scott is somebody who says in late 2021, he holds this press conference. The Loudoun County School Board agreed to conduct an independent review of the situation regarding the 2 assaults. This independent review was not announced, however, until a week later, until after the investigation had already been held. On January 14th, the Loudoun County School Board, who we just heard from Scott, announced operational changes to the school system purportedly stemming from an independent review, but noted that it would not be publicly releasing the view on how it handled those two incidents, citing in order, okay, so this is the cover-up. So he is now saying we can't release anything because family privacy, also says student confidentiality, also says attorney-client privilege. So Scott, the superintendent of the schools, is hiding everything from America and the public as far back as January 14th. This caused additional anger from a community that believed a report would be publicly released, and they demanded to know when it was coming. So on January 15th, the governor signed Executive Order Number 4 and said, go investigate this. They've done that. The purpose of this report: the special grand jury impaneled by the attorney is not required to file a report with the court. However, given the intense local and national public interest in the events leading up into this, we wanted to ensure transparency and share our findings. While we're not going into every detail that we learned here, we want to share some high-level thoughts with the community in a digestible manner. While we do not expect this report to be well received by all sides, the contents are an accurate assessment of what we've seen. We do not hesitate to point out our shortcomings. We've gotten testimony from more than 40 witnesses. We've reviewed info from over 100 pieces of evidence, and we have faith in our conclusions. They write, we believe that throughout this ordeal, that the public school administrators were looking out for their own interests instead of the best interest of the schools. This led to a stunning lack of openness, transparency, and accountability, both to the public and the grand jury. There were several decision points for senior public officials, up and to the superintendent, to be transparent and step in. They failed at every juncture. We conclude, though, that there was not a coordinated cover-up. Except for the May 28th email, both as a body, they were deliberately deprived of information regarding these incidents. They learned not from the superintendent's office, but from public reporting that it was the same assailant, okay? So this Scott Ziegler feller is hiding information from the rest of the school boards, from the rest of the committees, or the different people who are a part of this entire organization, all being hidden. And so they're not blaming them for the cover-up. They're just blaming Scott. They say, we also believe that the October 6th abduction and the assault of a female at Broad Run, the second one, could have and should have been prevented. A remarkable lack of curiosity and adherence to operating in silos by the school is ultimately to blame. We believe that they bear the brunt of the blame for the incident. They transferred the student from one school to another. There was a breakdown of communication among multiple people that led to the tragic events. All right. So now let's get to the summary. They tell us about the first incident. On May 12, 2021, less than 4 weeks after the students returned back from lockdown, a teaching assistant at the high school called SBHS wrote to her superiors about one of the students. That student turned out to be the assailant. This teaching assistant at the school, not even the teacher, the teaching assistant, she writes a letter. She says, look, if this kind of reckless behavior persists, I would not want to be held accountable if someone gets hurt. 16 days later, that same student assaulted a female student in the girls' bathroom. For nearly 3 hours after the assault took place, the individual who committed the assault was missing, and he was at large on campus for 3 hours. Around 2:15, the father of the girl who was assaulted arrived at the school. Dad shows up. He's very upset to learn what happened to his daughter. He became very loud after initially being denied entry into the building. They didn't let Dad even go inside. They call him and they say, hey, there's been an incident with your daughter. What kind of an incident? Well, there was something happened in a bathroom with another student. Okay, what do you mean? Well, there was something that, we think it's best that you just come down to the school. Father shows up. Okay, there was an incident where there was penetration or something. I don't know how they break that to a parent. He says, what are you talking about? Where's my daughter? Let me in the building. He's denied entry, so he starts losing it. Shortly after 2:30 p.m., the father had been escorted from the school, but the individual who committed the assault was still at large in the building. The school's in charge of the kid. They've got it covered. Dad, get out of here. You're being loud and bothering us. During this time, the Stonebridge principal reached out to the superintendent's office about getting a no trespass letter against Dad. The schools are colluding now. So the local principal calls Scott, the superintendent. Man, this guy's crazy. He's really mad that his daughter was assaulted, and he's like acting like he's like out of control. So can we just like tell him not to come back here? And Scott's like, well, man, maybe. Let me think about that. So the public schools, their chief operating officer, arrived at the school that afternoon. Okay, the COO shows up. Superintendent's like, I'm busy. Oh, it's just a rape. Who cares? So he's like, all right, send the COO over there. I'm too busy. And so COO shows up and talks with the principal. At 3:30 p.m., COO sends an email to the superintendent, Scott, and other senior staff. He says, all right, he says, the incident at the school is related to policy 8040. Uh-oh. What's policy 8040? Oh, yeah. That's the rights of transgender and gender expansive students. See that? That's what their policy is. So he says, I'll send a Teams appointment. That's sort of like a Zoom meeting between 3:30 to 5. It's inferior. And we'll log in now and offer an update if you want to log in between now and then. He says, this is a transgender bathroom issue. He doesn't say that. He says it's policy 8040. We know what that is. So 6 people joined that Teams meeting, including the superintendent and the now deputy superintendent. We believe this Teams meeting was the beginning of the complete lack of transparency about the situation. So they all get in there, they get their story straight. They're like, wait a minute, was this really a transgender issue? Do we care about it? Whatever. Cover up begins. Shortly after the meeting ended at 4:10 p.m., the superintendent sent an email out to Loudoun County School Board, alerting them of the allegations of the assault at the school. At 4:46, Stonebridge principal sent out an email to the community about what had occurred. The email neither mentioned nor hinted at the assault that took place in the bathroom. Okay? Didn't even mention it. Instead, the letter focused on the father of the victim who arrived at the school. This email was drafted by the public information officer, ultimately edited and approved by the superintendent, Scott himself. So we don't know what's in that letter. They left that out for us, but something like, well, there was an incident at the school. Some father came out here screaming and shouting. Your parents, your kids may have heard about it, whatever. Doesn't even say that, oh, his kid got raped. At the June 22nd, 2021, Loudoun County School Board meeting, the superintendent now, in response to a question about assaults, says, he says, quote, to my knowledge, we don't have any records of assaults occurring in our restrooms. Absolute lie. They say that true. They say, we believe this statement was a lie. The superintendent later claimed he was, quote, viewing the question in light of policy 8040. But per the aforementioned Teams meeting, we know that the superintendent learned shortly after the incident that the Stonebridge assault was stated to be related to policy 8040, right? It's in the email. So the superintendent is just a total liar. And, okay, so there you go. I don't even know what else to say it. Grand jury says it as well. We believe this statement was a lie. So do I. On July 2nd, 2021, 2 petitions, arrest warrants for juveniles, were issued against the student for 2 counts of forcible sodomy pertaining to the May 28th assault. And that happened, relatively slowly, right? May, June, July. Okay, so as required by law, the court services notified Loudoun County Public Schools of these petitions. So we go back on these dates here, trying to sort of piece together these dates. He said that on June 22nd, the charges were officially filed July. As required by law, the court notified the public school superintendent of these petitions, right? One of your students just got charged with assault crimes. Those are very serious. Notify everybody else because there may be a predator lurking around your school. On July 8, 2021, the student was detained at the Loudoun County Juvenile Detention Center, but per state law released. As part of his release, the court said the student could not return to the school, and the individual was subsequently transferred to the other school, Broad Run. Okay. So he's like trespassed from the first school. He can't return to the scene of the crime. So the school and the superintendent, they just say, uh-oh, what do we do with this person? Well, we better just move him to a different school. They move him over to an entirely separate high school. In early September 2021, 2 female students at the new school, okay, so after the student gets moved, they're enrolled in an art class with the former SBHS student. He approached their teacher. They approached their teacher and they said, we need to move him away from us in this class. Can you separate us, please? The former SBHS student made them feel, quote, uncomfortable by the way he was behaving because he had discovered where their friend group was hanging out and he followed them around. The art teacher reported these events to the Broad Run principal, who failed to inform the teacher of the connection to the prior high school or that the assailant was a recent transfer. Nobody knows. On September 9th, just over 2 weeks into the new school year, the individual grabbed the shoulder of a girl, quote, really hard and kept tapping her head with a pencil during class. He tried to take the girl's Chromebook and ask her if she ever posted nudes online. He then asked another boy if his grandmother had posted any nudes online. The superintendent, the deputy superintendent, the superintendent's chief of staff all learned of this incident, and they all knew it was the same individual who committed the assault at the prior high school. And despite having his 12-page disciplinary file, despite wearing an ankle monitor, being closely monitored by Broad Run principal, knowledge of this incident by the highest administrators in Loudoun County, and a suggestion by the court services that a more serious punishment be given, the individual received nothing more than a verbal admonishment for everything that had happened. So no wonder he's tapping the pencil on the head. He's like, nobody cares about any of this stuff. Less than a month later, on October 6th, the individual snatched an unassuming female out of the hallway. He's in school at the new school. Nobody knows who this guy is. He's kind of this interesting individual with a ankle monitor. He's in trouble. Everybody's giving him little extra special attention, but he's allowed to have free reign. Abducts a female, puts her into an empty classroom, nearly asphyxiates her, and assaults her sexually. The individual was taken into custody that day, where he has remained ever since. So given the facts that was learned through this investigation, multiple witnesses testified that the October 6 crimes should have been prevented, and they expressed disgust, outrage, and sadness that they occurred. We asked the Broad Run principal whether he felt any responsibility for what happened to the girl, but he did not answer after his attorney objected and mentioned the Fifth Amendment. Good call. Yeah. All right, so some more details. Right, now that's all awful. Let's get into some more details here that make it worse. There was a May 12th email. On May 12, only day 14 of the in-person school year, another teacher's assistant wrote to a fellow teacher and her department chair about a student in study hall. Teacher's assistant says, "Good afternoon!" exclamation point. Even though he started the year very well, and though he gets along with his peers, the student seems to be having a problem with listening and with keeping his hands to himself. He has come into class more than once with his arm around a girl's neck. I've caught him sitting on other girls' laps several times. He doesn't need to be a global pandemic to say that that is unacceptable. His refusal and disregard to me and my assistant has us at our wits' ends. I understand the school year is quickly ending and that students and staff alike are counting down the days, but this kind of reckless behavior persists. I wouldn't want to be held accountable if someone gets hurt. One of the recipients to the email did not know who the student was and thought it was missent to her. She's like, who the heck is this? I don't know that person. She said that, no, I have nothing to do with the student. I didn't follow up or discuss it. I didn't want to invade that student's privacy. The other recipient, the department chair, viewed the email blithely. She testified that she was confused because she wasn't sure if the author meant get sick, like with COVID, or get hurt, or like something else. And she questioned the true motivation of the author. She says, oh, she probably just doesn't like transgender students. Oh, that's why she's pointing her out. She did, however, follow up with the student's case manager, who called the student's mother. None of this is documented in the student's file, and neither the department chair or the case manager spoke with the author or the emails, and nobody responded to that at all. So basically, everybody just like, yeah, it's not my problem. The department chair also mentioned this email to the assistant principal, who also questioned whether the author of the email had followed the proper protocol. He said this was a classroom management situation, and if it continued to happen, we would then escalate that to what would be a discipline referral. The assistant principal, however, also testified there had been other discipline incidents in the past, and that it was just the 14th day of instruction, right? It's just a new school year. So it was not predictive, but the email was a warning. The student had already caused enough problems to raise everybody's issue. And it was on the radar, but rather than trusting the word of a faculty member and asking her about the concern, it was not treated seriously. It should have been documented. Somebody should have spoken with the student. None of it happened. And 16 days later, another female student was assaulted in a classroom. Now, they give us some details about May 28th. They say from 11:46 to 11:59, late morning, the assailant was chatting with a female student on Discord, which is a garbage platform that censors and throws people off of it. It's a messaging application about calling a pass to, quote, have some fun. The students were using their Chromebooks to have their conversation. The two individuals had met in the bathroom 2 weeks before to have consensual intercourse, but never did so outside of the school. Now, at 12 p.m., the two students met in the handicap stall of a bathroom. The male student became handsy and then more aggressive, which caused bruising on her chest. Wait a minute. They had met before, but never outside of SBHS. At 12 p.m., the two students met in the handicap stall of a female bathroom. The male student became handsy and then more aggressive, which caused bruising on the female's chest. The female laid down with her stomach on the floor. The male held her arms down and penetrated her. While this was occurring, a special education assistant walked into the restroom. This caused the male student to jump up. The female student was in a lot of pain and got up slowly, and when she was in a seated position, the male student pushed her shoulders down and grabbed her face. The special education teaching assistant later said that she saw 2 pairs of feet under the stall at the high school, but she did nothing about it. She said, this was not an uncommon occurrence at our high school because somebody could have their period. They might need a tampon, or somebody had a boyfriend they had a fight with. And so the assailant later acknowledged that they usually don't do anything regarding the 2 pairs of feet in the stall. But after the teaching assistant left, the assailant began forced penetration against the student, this time orally. 12:24, the students left the bathroom. At 1:28 that same day, the principal emailed the director of the high school education and supervisor stating the following. Says in an email, director says, I have a female student who alleges another student attempted to rape her in the bathroom today. Okay, we're sending this to law enforcement. The girl is currently with the nurse. We will address this by the numbers. This is the same student who was transferred here from THS from a similar allegation. Now, it's unclear why the principal included that last sentence in his email or why it was relevant. We've seen no evidence that the student was transferred for a similar allegation. The fact that the principal included it at all, however, suggests he was skeptical of the veracity of the allegation from the outset. Right? So he's, in other words, meaning maybe this wouldn't have been an issue unless there was another incident that popped up. Like, he's almost being dismissive of it is what the the grand jury is saying, which is amazing. Around 2:15, the father of the victim arrived at the school. The school resource officer initially denied the father entry into the school because he did not have ID. The father called his wife, who was inside the school with their daughter, asking for help to get in. She told the father that they initially thought that there was an assault against her daughter was involving a sexual assault. That irritated and infuriated the father, who caused a scene, and the school resource officer eventually escorted him inside the building. The father was escorted out of the building at 2:30 p.m. He's furious, right? What do you mean she was in your school? You people are supposed to keep her safe, and we drop her off every day. You've got locks and keys all over. And what? So they escort him into the building and then out at 2:30. Now, handwritten notes indicate around this time that the now deputy superintendent learned she knew of the allegation that the victim was anally penetrated and that the assailant was, quote, missing. He's gone. out of pocket. The county sheriff's office report notes that the assailant, quote, was not able to be located at this time. A teacher who knew the assailant was then pulled in to try to locate him via camera footage. Emails indicate that at this time, the principal was concerned about obtaining a no trespass against the father. The assailant was not found until nearly an hour after that email was sent, while leaving the school at dismissal. Given the nature of the allegations, we are dismayed at the lack of the concern about the assailant being at large in a school for over 3 hours and believe the school should have been locked down to find the individual who just raped another student. The public school's chief operating officer, the same COO we talked about previously, arrived later that afternoon and had a discussion with the principal. The COO testified that somewhere along the line of the conversation during the day, somebody had informed me that the incident in the restroom did involve a young man that was wearing girls' clothes. At 3:30 p.m., the chief operating officer emailed the superintendent, Scott, that the now deputy superintendent, he said the following: "Yeah, this incident is related to the transgender bathroom policy, policy 8040. I will send the team's appointment and we'll all update each other." The meeting lasted for 30 minutes. Everybody was on it. The principal says that, quote, all of the staff there wanted to meet with me and hear directly from me about what happened that day. Nobody else we questioned about this meeting could recall the events of the discussion, which we view as critical to wow, man, these people. It says nobody else we questioned about this meeting, however, could recall the contents of the discussion. So the principal gives us a little bit. They say, what happened at that meeting where there were a bunch of you on there right after this happened and you were all covering this up? Principal says, they just wanted to hear from me what happened. They go to everybody else on the meeting and they say, can you tell us what happened? But they can't recall. Nobody we questioned could recall the contents, which we view as critical to understanding what actually happened. They say that we believe there was intentional institutional amnesia regarding this meeting. Amazing. All of these professional educators of students, institutional amnesia. It just went away. Don't even know what happened there. After the meeting, multiple messages were sent about the incident. At 4:10, the superintendent privately emailed the entire school board. Said in the email, "Hi, everybody. The purpose of this email is to provide you with information about an incident at the school. This afternoon, a female student alleged that a male student assaulted her in the restroom. The sheriff's office is investigating the matter. Secondary to the assault investigation, the female student's parents responded to the school, and they caused a real disruption by using threatening and profane language that was overheard by staff and students. Additional law enforcement units responded with the school to assist the parent." All right, so she's a lot more agitated about that. Alleged a male student sexually assaulted the bathroom, but no, the father was the one who was acting threatening and profane. Okay. Now, publicly, they sent a different message to everybody else. This is what she sent out to the rest of the world. She said, "Hi, parents. Good evening. Stonebridge families, we're grateful to come into your living room today. This is Stonebridge Principal Tim Flynn." Tim said the following. He said, "There was an incident in the main office area today that required the sheriff's office to show up. The incident was confined to the main area, the entrance of the school. There was no threat to the safety of the student body, except the student that got raped, by the way. The incident was witnessed by a small number of students who were meeting with staff adjacent to the main office. What were they meeting for? A rape investigation. Counseling services and the services of our unified mental health team are available for any student who may need to talk about today's incident. The incident is the father showing up and being outraged that the school let his daughter get raped. Students might have noticed that the sheriff's office personnel on campus, and I wanted to let you know that something out of the ordinary happened at school today. The safety of our students and staff is the top priority of Loudoun County Public Schools." Oh my gosh. I don't know how these people even sleep at night. How do they live with themselves? The whole thing is missing. It's burying the lead. The whole incident is about a rape of a student. And he makes it about the father who showed up, and all of the students are going to have to get counseling because they saw him, get agitated. The grand jury continues explaining, they tell us, this statement, which was drafted by the public information officer and edited and approved by the superintendent, deliberately makes no mention of the assault that took place just hours earlier, nor does it mention the fact that the assailant had gone missing in the school for hours after the assault occurred, jeopardizing the safety of all students. So the Loudoun County officials, according to the grand jury, they repeatedly cited privacy concerns. Oh, we can't talk about that because he's underage. It's a student, we can't, HIPAA. They jeopardize also it could jeopardize the investigation. That's why they didn't put it in the email. However, for a school system that repeatedly trumpets the importance of student safety, they really dropped the ball in this instance. Yeah. Alerting the community. There was certainly a way to inform them about allegations without sharing the information about the students, or without jeopardizing the investigation, but they chose not to do so. We feel that since they sent an email out about the disruptive parent, they should have also sent an email out about the students. However, they didn't. Now, the assault occurred on the Friday before Memorial Day, and the school resumed the next Tuesday. After it happened, they had no formal policy on how to handle the situation. So they came up with a temporary solution. What'd they do? They said, well, we can just keep him in school. We'll just allow him to come back to class. The following day, on June 2nd, the assailant was back in school on his computer, deleting conversations and evidence from Discord. What? Okay, so the policy is that we'll just bring him back and just put him on the other side of the classroom. Just give them separate desks. Make sure they're not, near each other. Don't let them talk to each other. But he comes back on June 2nd. Okay. So then we fast forward a couple weeks. Parents are absolutely outraged, obviously. The June 22nd school board meetings comes up, and we see what happens at that meeting. Now, much has already been debated about this meeting. Political parties and candidates across the country have used footage from the events to promote these things for partisan purposes. The father who attended one of these meetings was to discuss the policy 80-40. The father of the daughter who was assaulted testified, said, from what I understand from this policy they're voting on and what just happened to my daughter, he says, you know something? I need to go check this out. He said that he was planning on just being an attendee and observing, but now when I go through the little line, somebody handed me a speaker ticket and I wasn't signed up or anything. I don't even know what the ticket's for. I had never been to one of these before. But he later observed that an individual was accosting and bullying his wife. He testified the woman told him about the assault of his daughter. The woman came up to him and said, no, that's not what happened. Your daughter's a liar, basically. An LSSO sheriff warned them about civility. The father said that the woman was threatening him, said that she was going to ruin his business on social media, to which the father responded in colorful terms. A deputy then grabbed the father and, after a scuffle, arrested him. The arrest stemmed from a personal altercation. It was not directly related to the school board meeting. Okay. Father shows up. He wants to testify. Other parents are saying, you're a liar. The school says you're a liar. Your daughter's a liar. She's just trying to make this whole thing up. And I'm going to ruin your business. Wait until the trans community hears about what a bigot you are. They're going to take you out. And so he starts losing it right now. He goes to the school. They threw him out. He goes to the school board meeting. He gets accosted by other, individuals wearing rainbow hearts on their chest. And this is what it looks like. This is the scene. Scott Smith arrested for getting into an altercation with somebody who called his daughter a liar.
Girl and a boy with the boy is wrong. God says men and women are united in one, not men and men or women and women. I also think that transgender
So there's Scott,
is wrong too.
and this lady is apparently yelling at him. I'm going to destroy you. This cop says, you're done, buddy. Don't you dare defend your daughter here. All right, now you're getting out of here. You're done. So they tackle dad. And everybody's just sort of ignoring. Yeah. So dad's now getting arrested. Daughter gets raped at the school. Everybody knows what happened, and they just arrested the father of the victim. That's Scott Smith. So shout out to Scott Smith and his family for all of the hardship that they have gone through. Holy moly. I mean, what a joke. All right, so you can see that's what they're talking about. The grand jury is talking about that in this paragraph. He gets escorted out. The father testified in front of the grand jury. He says, look, I resisted. Yeah, that's true. I did resist for one reason and one reason only. One, I knew that legally and constitutionally what they had done was wrong, and I also knew this was my best way and best vehicle to bring it to light. For the last month, nothing had been getting done. Everybody had been offered therapy and counselors but us. According to Loudoun County, this assault of my daughter didn't happen. Later that evening, a school board member asked the superintendent, do we have assaults in our bathrooms and in our locker rooms? And he said, I would hope not, but I'd like clarification. The superintendent responded. He said, to my knowledge, we don't have any record of assaults occurring in our restrooms. The principal who attended the team's meeting, and that's a lie, right? He knew that there had already been one. The SBHS principal who attended the team's meeting with the superintendent that afternoon testified, that is not true. Another witness testified the superintendent's statement was a bald-faced lie. And the grand jury agrees. In the wake of the June 2022 board meeting and the publicity surrounding the father's arrest, multiple school board members reached out to the superintendent asking for additional information. Now, he had kept it all from them. Remember, all of it was sort of being censored for a lot of it. On June 27th, one board member emailed the superintendent saying, this family lives in my district. At the meeting, the father was arrested. Can you update the board on these allegations and the investigation? I understand it would be confidential. The superintendent responded the next day saying, this matter is under investigation by law enforcement and I'm unable to provide an update. On June 28th, that same board member emailed the superintendent and the entire school board saying, since the family has gone public, will there be a statement if someone is arrested for assault? And attached a social media post by the father of the victim. The same evening, another board member emailed the superintendent and the entire school board twice asking, has there been any update in this case that you can share with us? Can you please give us a high summary of the incident that took place at the Stonebridge School at the end of May? I understand there's an ongoing investigation, but please share what you can with the board and keep us updated on the progress. The superintendent, Scott, responded and he said, this matter is under investigation by law enforcement and I'm unable to provide an update. Now we get to an arrest and finally a notification. We heard testimony, the grand jury speaking, from the sheriff's office that they, quote, did not see fit to charge or arrest the assailant in the wake of the assault, but that calculus changed after the school board meeting where the father of the victim was arrested. The assault became publicized and Loudoun County was put into a national spotlight. So they were not even going to charge this individual until dad got arrested and everybody started demanding it. They were just going to write the whole thing off. Other testimony and documents seem to support that narrative. School officials testified that multiple individuals from the sheriff's office told them that the assault was an iffy case and a shaky case. Additionally, after interviewing the victim and the assailant, the LSSO collected very little additional evidence prior to contacting juvenile intake of the court services. So, for example, the certificate of analysis from the lab of from the victim's physical evidence recovery kit, PERC, and the reported sexual assault nurse examiner, the SANE, it did not come back until September. So they're doing DNA evidence, they're matching everything up, and they go, it's an iffy case until all of it comes back. Then it comes back. Uh-oh. On June 30th, the sheriff's office provided juvenile intake with its initial report. On July 1, a detention order was authorized against the assailant for 2 charges. And on July 2nd, 2 petitions and a detention were ordered. July 8th, the assailant surrendered himself, was taken into custody, and transferred. For the next 14 days, he spent 23 hours a day in lockdown. During this time, his probation officer advised him, use this time wisely and think about how things need to change to never come back to where you are right now. The probation officer also noted during this time frame that he had adjusted a little too easily to this experience and doesn't appear to have any real concerns at the moment. On July 26th, the assailant was released to the custody of his grandmother, who lived in Pennsylvania for 2 weeks while the mother went on a pre-planned vacation. Mom still wants to get that trip to Hawaii in. The release came pursuant to Virginia law, which requires a juvenile defendant who is detained to be tried within 21 days or else released. As part of this release order, the assailant had to wear an ankle monitor, was not allowed to return to the high school, and could not use a computer. On July 6th, though, the court services unit notified the superintendent of the schools of the pending charges against him. Done pursuant to the law, right? If anybody is being charged, got to let everybody else know about it, sort of a notification requirement. This notification was the source of public squabble and the subject of a series of letters between the public schools and the sheriff's office. Public schools claims that the sheriff never notified them of the offenses, and the grand jury doesn't believe that. They say no. They say both Loudoun County Public Schools and Loudoun County Sheriff's offices, they both knew within minutes of each other about the assault on May, and they worked together that same day to collect the student statements and evidence. An offense occurs on the day of the incident, and they knew about it on the day. A petition, however, is a formal charging document under Virginia law. That's when the notification was required. That was done. However, juvenile intake did not call the superintendent's office, email the superintendent, or send a copy through the mail. Instead, the process in place at the time was sent via inter-office envelope picked up at the courthouse. It's unclear what happened with the envelope. Due to privacy concerns, the method of notification was a little bit difficult during the calendar year. There were 39 notifications sent. Unknown if they ever saw them. All right, so some technical stuff that, they're all going to point to. Stuff gets lost in the weeds there. But the point that the grand jury is making is they knew about the incident. In other words, they may not have known about the formal charge, but they knew about the incident because they were there. They all responded to the incident. So the notification requirement is just to kind of notify you that things have escalated. But they should have been on notice that this student was problematic. Now, all this is going on. They're going to defer over to, we didn't get notified about this, but they knew. Grand jury says they're liars. They knew better. The transfer starts here. They tell us that the process of transferring the student from one high school to the other encapsulates the lack of communication and the lack of curiosity about these types of charges. In the ensuing weeks after the assailant was released from custody, the court services unit learned from the assailant's family information that caused them to keep a tight eye on this kid. The assailant's grandmother, with whom he had spent 2 weeks after being released in custody, called the probation officer just to, quote, make sure he knew how bad things were. She also called the assailant a sociopath and says it does not care about consequences. Nice. So even grandma's like, this kid's a lunatic. The mother of the assailant pleaded with the probation officer that she had been begging for help from the schools for years, only to have them, quote, enable his manipulative capabilities by siding with him and trying to be the fair and neutral party, often discounting my approach and recommendations with respect to reasoning and action. Only after his actions escalated to concerning levels did they listen to me. Most recently, I talked to the principal. We had a conversation in his office after the May incident. And after noting that I had tried all these years to discuss concerns, his staff said, now we're listening. I strongly encourage us not to wait. Otherwise, he's going to be another statistic in the adult circuit. So in late July or August, the principal of the school called the principal of the other school to alert him of an involuntary student transfer. One principal calls and says, all right, look, sorry about this. You've got a student coming your way who's not particularly ideal. So get ready. The SBHS principal mentioned the student was facing a sexual assault charge and had a court order, said he can't come back. The principal at the new school did not ask further questions about the charge or the incident that led to it. Oh, what is it? Oh, sexual assault? Oh, gosh. I mean, I thought it was going to be something serious. No problem. Yeah. What grade is he in? Perfect. He'll fit in great. An involuntary transfer requires a formal letter. And even though the principal acknowledged it was unusual for a court order to not allow a student to return, he decided to wait directly to hear from somebody else. School year began, yet it's not until much later that anybody really know about any of this stuff. On August 24th, the probation officer reached out to the assistant principal, alerted him the student could not return. The following day, probation officer was calling around as well. After talking with the assailant's mother, the director of school administration talked with probation, finally got a copy of the order. That started the transfer process. All right, so the rest of this is about transferring. We have another incident now in September. The grand jury writes, they say, it is our considered judgment that the October 6th assault should never have happened. Had any one of a number of things happened, it would have been prevented. One would have been the transfer of the student. A lot of different people were alarmed. Some people called it very disturbing. The director of the school, should have communicated this. Discipline to these incidents fell to the principal. He spoke about the incident with the probation officer, who was concerned about ongoing bizarre behaviors by the student, saying, I wonder why he would think this behavior is all right. Probation officer texted the Commonwealth's attorney. The incident kept going on. All right, let's get to this October incident. On October 5th, the assailant sent a cryptic message to the female high school student on her computer. The message was not seen until 2 days later. Shortly after the cryptic message was sent, the assailant followed the female and her friend into the hallway. The girls began running down the hallway from the assailant into the female restroom to get away from him. The assailant sat outside the restroom waiting for them. The girls eventually exited and ran the other direction from him. The following day after math, the assailant asked the female student to walk him to his next class, which she did. Along the way, he stopped outside a different classroom and peered in to find it unoccupied. Video shows the assailant waited for a group of students to walk by and put his arm around her neck, abducted her into the classroom, and closed the door. Once inside the classroom, put a chokehold onto her student, and then she could not breathe, and then he assaulted her. Upon leaving the classroom, the female student went to the restroom, met a friend, told her what happened. The girls left the restroom, saw the principal in a nearly empty hallway where he was working from a mobile standing desk. Instead of telling him what happened, they adjusted their masks above their noses and kept on walking. Otherwise, he'd be very angry at them. They subsequently went to the main office where they reported the incident to the school resource officer. Didn't even tell the principal. All right, later that day, juvenile intake issued a detention order and 2 petitions for abduction. It's unclear why the more serious charge of abduction with the intent to defile was not considered. The assailant was taken into custody. He's remained there ever since. The victim had spent her freshman year of high school remotely, so the 2021-2022 school year was her first real experience with high school. Lovely. Just more than a month into school, as the victim's father testified, an assault upended her life and the life of her families. Financial impact created untold stress, and the father got arrested for it. Affects her mental well-being, and the whole family's, devastated. Right. Perfect. Though the principal testified that he cares very much about the victim, he also acknowledged he's never spoken to her about the incident. Yeah. The father testified he would have expected much more interaction from them, but of course they don't care. They're all in protection mode. Fallout was massive. October 7th, the director of safety and security emailed the chief of staff, said, per our convo, a student was arrested yesterday at the school charged with abduction and assault. Student allegedly forced a female student into the room and assaulted her. We're going to have to talk about this. They sent an email, said, good morning, board members. Please draw your attention to the emails below. I've been advised that there's going to be a press release. We'll keep you notified. Director of communications responded. Luke Rosiak from the Daily Wire emailed the public officer and asked about this. And he sent a letter. So shout out to our friend Luke Rosiak over from the Daily Wire. He says, hey, jerks, I'm about to report that a student was charged was the same student at another incident. And they start freaking out. The public information officer forwards the email to the director of comms and many other directors. FYI, they say, I've worked with counsel. We're going to handle this. No further action. Enjoy your day. Team, take no action. I've got this. 3 days later, the Daily Wire published an article stating, yep, it's the same person. The school didn't do anything about it. They just moved them from one location to the other. On October 15th, the superintendent, Scott, he held a press conference. He says the following. He reads a prepared statement, no questions. It's got input from the Donovan Group. And the grand jury says it contained numerous critical inaccuracies. He says they're complying with the law. He's making, conversation. He stated that the board member is making decisions about policy 8040. Other statements are released. Nobody's taking ownership for any of this. They talk a little bit more about Title IX. Very little cooperation from the Loudoun County Public Schools. Say the grand jury specifically, they say, we highlight the lack of cooperation from the schools and the majority of the board members throughout the investigation. What a bunch of really, really honorable public servants. They don't even work with the grand jury who's investigating their own malfeasance. Love it. We expected these public servants to provide clarity, transparency, and a willingness. Instead, we were met with obfuscation, deflection, obvious legal strategies designed to frustrate our work. Well, they're all in protection mode. I mean, they're all honestly, as a defense lawyer, yeah, you're going to be telling them to shut their mouths because they're responsible for catastrophic gross negligence, maybe criminal negligence, depends. On April 7th, the first act of the special grand jury was to authorize subpoenas. Though the public schools said that they were going to cooperate, they did not. They experienced a very different posture behind closed doors. So just remember that. Every time these board members are out, no, we care about students. They don't care. From the outset, Loudoun County school boards put up roadblocks to obstruct our investigation. The chairman, the superintendent, both represented by the same attorney, submitted a motion to quash the subpoenas, saying that they're invalid. The court rejected the arguments. 6 days later, an elementary school principal, represented by the same attorney, filed a motion to quash. Court rejected those arguments. Same attorney filed another one, rejected. Teachers, many of them, motions to quash. They don't want to talk about anything. They filed a civil complaint in court seeking an injunction to stop the grand jury. The grand jury is noticing that they're trying to stop their own work. The complaint recycled the same garbage arguments that we heard from previously. We sent subpoenas to school board members, true to form, lawyers for the school board and the superintendent. They filed motions to quash. They were obstructionists throughout the entire process. They were trying to control the flow of information. They say, we received an email about policy 8040. Even though it should have been produced many months earlier, this email was produced pursuant to a different subpoena. Division counsel learned we had this email. School board members testified. Yeah. There is absolutely no evidence the father said anything about policy 8040 or that he even knew what it was. No school board member could provide any evidence. All right. So they've got recommendations. They say, we have the following recommendations: better transparency, better communication. They say that they should re-examine their transfer process. Don't transfer rapists from one school to another. They say that the safety and security needs to be more involved, in that stuff. The school board should tighten its policies about the type of apps available to students. Maybe, don't let them get Discord. The elected members should limit the degree to which legitimate members are protected by attorney-client privilege, so they should open up a little bit more. Actually talk about criminal conduct by students. Strengthen avenues of support for advocacy. The superintendent's recommendation for the non-renewal of the teacher's contract should be the subject of a separate agenda. And in conclusion, they write, although Loudoun County Public Schools has taken positive steps, such as increasing different provisions, whether intended or not, this practice conveys to the public a sense of apathy. They have not served our community well. The culture needs to change. Stronger leadership would address problems head on. As 9 members of this community, we are certain the public would reward leadership. The above is the final report of the special grand jury and reflects the true and accurate testimony and evidence. Signed by Kenneth P. Alswad, dated December 22nd. And the rest of this is all attachments. So if you want to go through all of the attachments, you can see some of the Discord messages. We're not going to go through all of the emails. He referenced a lot of this, but you can see some of the conversations. Right. School board meetings, grand jury's got all of the attachments. You can see probably some of the motions to quash while they're trying to shut everybody up. Title IX. Loudoun County Public Schools. Doug, not trying to be difficult. The original email stated, I have a student who alleges another student attempted to rape her. Says the allegation is not of a sexual assault, but of an attempted sexual assault. Okay. And he's right about this. Chief of Staff. He says, well, your email says it wasn't an actual rape. It was an attempted rape. So he goes to the law. Sexual assault means the following. He says, my review based on the information is it doesn't rise to the level of Title IX. An allegation of rape, yes. An allegation of attempted rape, maybe. So they're having a really difficult time defining, what should we do about this? So the public schools chief of staff, Mark Smith, is like, well, it's not really rape, is it? To use a Whoopi Goldberg vernacular. And so that, my friends, is what's happening out there in Loudoun County. And, honestly, who knows what's going on in your own local school boards, because when you get a bunch of disgusting bureaucrats together who get to reign over their little fiefdoms and take control and power and endless gobs of money, all in the names of the students, they'd rather have total control over your kids than you have any control over your kids. And that's why people like Scott Smith get arrested. One of the most disgusting stories we've talked about here. And we will continue to cover it. And shout out to everybody who's done the heavy lifting on that, including the guys over at the Daily Wire. What a story. And shout out to Speech Unleashed for suggesting this story and recommending it that we cover it. Very, very nice ping.